Ready to go. Yeah, I'm going to speak with you about the Supreme Court, and not for the first time, but now in light of the fact that the 2025-2026 term of the Supreme Court has officially concluded. We're able to see the decisions in total, and there were a lot of really significant decisions that came down about 10 days ago. We didn't spend a lot of time on them last week because we were talking about the 4th of July. This week gives us an opportunity to digest and to begin to reflect. I think this may take us actually a couple weeks, what the Supreme Court is doing. And I saw a commentary. It's actually very interesting. One of I guess, the great-great-grandson of the justice who wrote the Dred Scott decision, and another person related to them, black and white, talking about the 2026 term and the Dred Scott term, comparing them. And a number of analysts, Gwendolyn Effel at Howard University's 14th Amendment Center, et cetera, have indicated that they think that this may be the worst term in the history of the Supreme Court since the Dred Scott decision. And I just want to focus on that decision and the parallels for a moment, because that's something very strong to say about this Supreme Court. The Dred Scott decision denied that African Americans could be citizens of the United States, and therefore allowed the slave trade, the practice of slavery, the dreadful, awful institution of slavery, to spread to new territories and new states, to upset the delicate balance between free states and slave states prior to the Civil War, and led very directly to the Civil War. And the right scenario here, I want to be as clear as possible about this, is one in which the people of the United States are polarized, are divided, but they are using their politically accountable branches of government, especially Congress, but also the presidency, and their power to elect their representatives to attempt to reckon with their sharp differences. And the Supreme Court, right, which is a non-accountable institution, it's an institution the members of which are appointed for life, do not have to face re-election, do not have to listen to constituents, intervenes, overrides, and takes off the political agenda some of the most pressing issues of the day. I think that is the most important parallel. And the term that is often used to describe this is an arrogation, right? And so the idea that the court is usurping from the political branches decisions that are intrinsically political. And then we can add, it's not just the hubris of the court to wrest from the political branches decisions that would be better made by accountable elected and re-elected officials. It's also that they do so in ways that seem not to be limited to the principles of the Constitution that they are assigned the special role of protecting, but that allow them to intervene in political and policy questions. That seems to me to be the precise parallel. It's not the case that the Supreme Court is trying to reestablish slavery in the United States or to spread that dreadful institution, but it is the case that the Supreme Court is preventing the Congress and the President of the United States and successive Congresses and presidents, and by the way, previous courts, from resolving sharp conflicts about the transition into becoming a multiracial democracy, about what kinds of powers we want and don't want the President of the United States to have, about what kind of society we want to be. Do we want to be a society that gives safe harbor to people who are in danger, oppressed, in distress in their home countries? Do we want to be a multiracial democracy? They are, and let me be as clear as possible, I'm sure you know, 6 of them generally are intervening in these fraught, difficult political disputes in a way that short circuits and bypasses the political process of the Constitution. And so I'm going to say 2 things. The first is that I think it is clear that we are now beginning a new era of constitutional law. The long period of what might be called 20th century jurisprudence, which really begins in the 1930s and the accommodation of the New Deal within the American constitutional structure, in particular, independent agencies being created by Congress but getting delegated authority that then get managed by the executive, but with limits on the executive's ability to unilaterally control those agencies because they're exercising regulatory, congressional, statutory authority. The Supreme Court, in a few different decisions, but most importantly, the Trump v. Slaughter decision, has fundamentally restructured the balance of power and the entire structure that Congress has created to graft a administrative state into our 18th century Constitution, and at the same time, especially but not exclusively, in the Calle, right, the Louisiana versus Calle voting rights decision, has fundamentally undone the Voting Rights Act and the ability of Congress to enforce the 14th Amendment through statute, and has licensed in so doing absolutely unrestrained partisan gerrymandering that is going to, let us be clear, undermine accountability and the ability of the minorities in many states to get effective elective representation, to use their suffrage, which is not being denied, to translate into actual ability to impact the outcome of elections in ways that are clearly rigged in advance to prevent them from actually being protected by the principle of one person, one vote. These are deep cuts into the fabric of American democracy, into the principle that every person should have roughly equal power and capacity, that their right vote should count for one and only one, and also a fundamental assault on the balance of powers, the separation of powers, on checks and balances, on the architecture of our Constitution, in which one branch is, right, arrogating to itself the power to restrict and restrain the power of other branches. I think not because, right, those branches are straying from the power that the Constitution assigns them, but because they don't like the way Congress is using its power, or because they prefer the way that the current president of the United States is using his power. And so, to make it as clear as possible, there's a concept I first encountered it in the writing of John Rawls, but I think it comes from multiple sources, of the judicial virtues. And so a judge is given great power to administer and interpret the law, in our case with our high court. That includes the constitutional law, the fundamental law of our society, that is the fundamental expression of popular sovereignty. And the judicial virtues have to do with a certain kind of restraint and forbearance, with a recognition that you are not an elected official, that you are an appointed official, that you are appointed to the highest position in the, right, pyramid of legal institutions in our country to play a specific role. And that although you may have policy preferences, partisan views, views about the right way to resolve some of the most fractious issues of our time, your role as a judge is different from your role as a citizen or perhaps as previously a politician. And the idea that the Roberts majority is not displaying the judicial virtues, that they seem to be acting on the basis of their partisan political views, not acting on the basis of consistent principle, not acting on the basis of the principle of stare decisis or respect for precedent, I think is threatening the legitimacy of the court, and the way in which they're exercising this power is also threatening the very constitutional structure of the United States. And maybe the better way to put this is that, as we discussed last week, it is making clear that the constitutional structure of 1789 no longer really functions in 2026. So it's a time to get back to basics and really begin to take up Jefferson's challenge, which is to say that the people of the United States or of any nation have the capacity to reform their government when their government does not allow them to affect their safety and happiness, does not protect their unalienable rights, does not preserve their sovereignty over their fundamental law. This term makes clear that we are at this juncture. And so that's where I want to focus. And I think it will take me a couple weeks to do this. So today I'll try to do some preparatory work, see how far I can get. Before I do that, as I often do, I want to spend just a few minutes on the news of the week. I won't say very much about Iran, other than I think we are moving in the direction of a resumption of greater warfare. I don't suspect it will be full out warfare, but it could be, because frankly, both sides are dug in. The Iranians want to maintain unilateral control over the Strait of Hormuz. They believe this war has accomplished that for them, and they believe that it is in their essential interest to emerge from this war in a posture that allows them to maintain that leverage. And to do so, they are guiding ships through the strait and attacking ships that do not seek their authorization or follow their direction. And of course, this is asymmetrical warfare. They are, yes, attacking various bases in the region where the U.S. has its facilities, its troops, its supplies, its provisions. But having said that, they're not being very effective, and nobody really thinks, I don't think, that they can be terribly effective. They were somewhat effective during the period of the hot war, maybe more so than has been officially reported to Congress or to the people by the military or the president, but they do not have the capacity to go toe-to-toe with the United States. And so they are focusing their attacks using inexpensive, low-tech drones against ships that are not military vessels, that are commercial ships, mainly tankers. They move very slow. They're very vulnerable to attack. And really all you have to do is show a willingness to attack one, and all the traffic stops. The United States, on the other hand, is obviously attacking Iranian military and infrastructure sites. And by the way, 170 strikes in 48 hours. This is an intensive campaign. I think the effort is to show the Iranian regime that they have to play ball in the negotiations. They have to reopen the Strait of Hormuz, or else they're incredibly vulnerable to attack. It's just not clear how much the Iranian power structure cares about that vulnerability. The news I will spend more time on is the withdrawal of Graham Plattner, the man who had won an insurgent populist campaign and was the nominee of the Democratic Party to take on Susan Collins for the Senate seat, and who had had a series of controversies exposed in the build-up to, and then especially in the aftermath of getting that nomination, that many of the allegations concerned either inappropriate sexual overtures to women or actual sexual misconduct towards women. The death blow, the final right uh, allegation that made it impossible for Plattner to continue was an accusation of rape by a former girlfriend. And so Plattner has reluctantly and angrily withdrawn from this race, indicating that he sees this as a conspiracy by the establishment to undermine his campaign. And some of the timing of this, right, these allegations did not come to light early in the process, such that the voters of Maine would have time to take them into account. The most damaging was revealed only after he had secured the nomination. And I'll just say this very quickly. Clearly, the woman in question did not want this to become public, but at some point felt she had no choice but to share with the people of Maine information that she thought was relevant to judging the character of the man they were about to vote on. So I don't think you need a conspiracy theory to explain this, but I want to connect this to something deeper, right? And this is to the hunger for non-institutionalist alternatives to politicians and policy. I'll give you a statistic I'm still working with. I'm not 100% sure this is right, but I read that every member of Congress owns their home. Not one rents. If that is accurate, it's a telling indication, right, that the members of Congress are in a different situation than large swaths of the American public, who, of course, are renters. And that although, right, thank goodness, the 21st century housing bill has passed, despite the fact that Donald Trump didn't sign it, the idea that the people in Congress are not like most Americans, that they are, if you will, career politicians, and that career politicians tend to be lawyers, tend to have relatively elite law degrees, tend to be relatively affluent. And let me say one more thing. I'm going to mention something my father said memorably on a camping trip. We were pulling our RV into a camping area, and he was chatting with the man running the area. And the man found out my dad was a lawyer and asked, what legal advice would you give? And my father's advice was, keep your nose clean, right? And the idea that people who are career politicians know that they are going to come under considerable scrutiny, that they are going to be subject to independent investigations by the other campaigns, right, opposition research team, and that they better be careful how they conduct themselves. And so they spend large portions of their life keeping their nose clean so that they can run for office. And that Graham Plattner is not that man, right? And that's part of what makes him attractive to the people of Maine, is that he is an oysterman, not a career politician. And people are hungry for an alternative to the kinds of politicians who seem to be cookie cutter, non-responsive, not right, capable of understanding, let alone representing their situation, their feelings, their interests. And now the people of Maine, 15,000 of whom volunteered for the Plattner campaign in a genuine groundswell of grassroots support, are going to not have the candidate they voted for overwhelmingly, and instead going to have a candidate that is not going to emerge from a full primary process. And of course, this is in the aftermath of something similar having happened at the highest level of Democratic Party politics in 2024, with Joe Biden being replaced by Kamala Harris. And so I'll say this very quickly, right? There is an appetite for anti-institutional politics, and the Democratic Party is having a hard time feeding it. I'll note, right, that the President of the United States has been found by a jury of his peers to have sexually assaulted E. Jane Carroll, who just, I believe, is getting the $5 million initial verdict from that. A court has decided that that can no longer be delayed. And so there is a double standard here. And the Democrats care more, frankly, about whether or not their candidates have engaged in sexual assault. In particular, there's a gender gap in our politics, but there's also differences in the positions, the values, and the right, I'll say, zeitgeist of the Democratic Party. And so there is a double standard. There is something that some voters in Maine are going to be able to point to and say this is unfair, but there's a deeper systemic issue, which is when, as we've talked about innumerable times, 90% of the country thinks the economy is fundamentally unfair. 80+% of the population believes both the political and economic system are so broken that they need major reforms, and they don't trust mainstream institutional politicians to do that work. And then you add that the Republicans have, right, taken an anti-institutional turn, and in the highly polarized environment we're in, the Democrats find themselves therefore opposing much of what the Republican Party is trying to do, and therefore defending institutions that really aren't working. This is not just about whether or not the Democrats will be able to capture control of the Senate. This likely diminishes their already long shot odds. It's by no means a foregone conclusion. I think there still is a path. It will depend on who the Democratic Party nominates in Maine and whether or not that person is able to, right, gain some of the trust of the voters who were so animated, excited by Plattner's candidacy or not. I'll stop there on the week's news, because I really do want to talk about this incredibly consequential term that just concluded with the court. And so I have on the board, borrowed from the New York Times, a list of some of the important cases categorized in a way that works for the time being. And I'll start with the idea that the Supreme Court pushed back on Donald Trump on some extremely important issues. They did not simply rubber stamp his entire agenda. They did not allow his executive order on birthright citizenship to be upheld. They did not allow him to fire Lisa Cook on the Federal Reserve Board's Board of Governor, and they did not allow him to impose tariffs. Now, I think if I've got it right, they did side with the Trump administration in those cases where the Trump administration had a position, maybe 27 out of 30 times, right? And so although those are high-profile losses, the balance of this court was clearly aligned with the current administration's agenda. And then I'll just add two things to notice here about two out of those three decisions. The tariffs decision, I think, is relatively straightforward and unlikely to be revisited. The Constitution clearly assigns the power to tax and levy and impose imposts, etc., to Congress, not to the president. And there's skepticism that, right, the Congress can delegate that power, and if it can delegate that power, then it can only be done within statutory constraints, and the president doesn't seem to want to abide by those statutory constraints. Don't get me wrong, I do think more tariffs are coming, but the tariffs will be shorter and lesser and more limited and not subject to the whim and will of the president. He can't impose them when he wakes up on the wrong side of the bed. There's a process via which they have to be imposed now. And that's the sidebar. The main thing I want to discuss is the Fed board firing and the birthright citizenship case. Let's start with Trump v. Barbara and the birthright citizenship case, and I'll say this very quickly. 6-3 decision, but actually only 5 justices voted to say that the 14th Amendment means what for nearly 150 years we think it's meant, that it is clear that its plain language means that all persons born in the United States and subject to the jurisdiction of its laws are entitled to all the rights and immunities of citizenship and are citizens of the United States and the state in which they reside, right? It seems so clear, and yet it's worthwhile noting only 5 justices said that that's what the Constitution means, and that although Gorsuch voted with the majority, he did so on statutory grounds and issued a concurring opinion to say that he did not accept the majority's reading of the Constitution. And what this means, and I want to be as clear as possible, is that there is a pathway for revoking birthright citizenship. It runs through, on the one hand, changing one more member of the Supreme Court, and on the other hand, changing the statutes of the United States to revoke birthright citizenship for certain classes of persons. And this is, I think, the beginning of a topic that we will go more deeply into, the idea that there is deep anxiety on the majority of the Supreme Court, on the 6 members of the majority, the conservative majority, about the racial transformation of the United States. And they are doing, I think, what they can, and very often not merely within the limits of precedent or what the Constitution and the law seems to allow, often in a much more ad hoc, unprincipled, inconsistent way, to allow the current president of the United States to do everything in his power to prevent the further racial transformation of the United States. And I'll just say this explicitly. I am deeply concerned about what's sometimes called de-documenting, right? We will see this when we get to the temporary protective status cases, right? That there were people who were legally allowed to enter the United States and who have been law-abiding, tax-paying members of our communities permitted to be here, who the court just allowed the administration to remove their status, to remove their permission to be in the country, even if there is good, clear evidence that the president and the administration did not follow the statutory procedure for removing temporary protective status, and more importantly, that the administration shows racial animus. We have the record. Donald Trump called Haiti a shithole country. He accused Haitian immigrants of eating cats and dogs. He said that they are poison in the blood of the country, or the nation, I should say. And we recognize, right, that this is the kind of rhetoric that was used by fascists who committed genocide in the middle of the 20th century. This is the kind of disinformation and lies that reflect racial animus, but also that stir it up, right? And so the idea that the Supreme Court decided to whitewash those statements, to say those don't reflect, right, a racist motive or racial animus, because as opposed to that, I guess they are mere xenophobia, right? The hostility to outsiders as opposed to hostility to a racial group. Never mind how, right, this is not dog whistling. This is not coded language. This is the standard tropes and rhetoric of racist politicians being used by the President of the United States against a group who then his administration removes temporary protective status from, and does so, right, without following the statutory procedure. And the majority of the Supreme Court says that this cannot be reviewed. And then you go back to birthright citizenship. You have 4 justices saying the Constitution does not protect it. I've said to you before, there's nothing that can be done to prevent the United States from becoming a country without a racial majority, in which Europeans lose their majority status, or white Americans lose their majority status, let us say by 2050, right? I think that's conservative. It's probably coming more quickly than that if the current demographic trends continue. Nothing that can be done to prevent that short of ethnic cleansing. And what I find so chilling about the birthright citizenship case, about what we hear from people like Stephen Miller or the new head of the Department of Homeland Security, is that they seem to not want to stop the deportations with those who are undocumented. They are pursuing a strategy of de-documenting, of removing the legal authority to be in the country from people who had hitherto have had it, right, in order to then make them eligible for deportation. And that if, right, this becomes, and I think that the effect of this decision will be to make this really important to Republican politics going forward into 2026 and 2028, in the same way that abortion was important, in the same way that losing 5-4 decisions incentivized the Republican Party to continue to pass laws restricting the right to abortion and to continue to try to capture the presidency and the Senate so as to be able to appoint people to the court who would undo the right to abortion. We're going to see, I think it's quite likely that we will see something similar happening with birthright citizenship, and that the ultimate incentive here is going to be revoking birthright citizenship, de-documenting potentially people who are citizens of the United States. And I know this sounds like a nightmare scenario. I hope I'm wrong, but I just have to note that what I think I see, and I'm certainly not alone in the current majority, and especially in things that Gorsuch and Alito and I'm sorry, Clarence Thomas say in their opinions, is real anxiety about the racial transformation of the United States, a real kind of culture war vision of the battle for the future of the United States. I'll get more into this in a moment, but I think in those circumstances, the idea that the Supreme Court is not far from licensing the revocation of birthright citizenship, and then the question will be, can this be done retroactively in ways that will, right, lead to constitutionally permitted legal, racial, or ethnic cleansing in the United States of America. It is a chilling possibility. So I now want to look for a second at this other, what seems to me to be an important Trump loss, and yet to be highly ambiguous. So this is Trump v. Cook, right? Lisa Cook is the member of the Federal Reserve Board of Governors who Donald Trump has, cooked up, trumped up, sorry, right, allegations of mortgage fraud against them. There's been absolutely no finding independently via any kind of judicial holding that she did this. As a matter of fact, it seems quite clear that she, at most, may have made a mistake on a paper filing, and before she was a member of the Fed board, and it doesn't seem to have any bearing on how she acts on the Fed board, right? But nevertheless, the Supreme Court held, again, 5-4, that she can't be fired. But I just want you to notice something else, right? When it comes to regulatory firings, right, and this is Trump v. Slaughter, not Trump v. Cook, where he wanted to fire a member of the Federal Trade Commission, he was allowed to do so. And he was allowed to do so on the basis of the unitary executive theory that says that basically everybody who is a member of the executive branch serves at the will of the president, even if Congress has created an agency on the basis, on the condition that the members of its boards not be fireable at will by the president, because it's important to them that the agency function in a non-partisan way. And so the president gets regular appointments, but there are regulations that say there have to be a balance between the two parties on their boards, and that the members of the boards can only be fired for cause, for malfeasance or failure to perform their duties or corruption. Donald Trump fired Slaughter not for cause, but because he doesn't like the party and the positions that she represents, right? And the Supreme Court allowed this, and allowed this 6-3. It's a fundamental alteration in the balance of powers between the two branches of government. But here's what I want to focus on. The right Fed board firing case is 5-4. Why the discrepancy between the two? Because in the first case, right, Donald Trump is being allowed to fire a member of an independent board on the basis of the unitary executive theory. On the second case, Donald Trump is not being allowed to fire a member of an independent board despite the unitary executive theory. Well, why? Because John Roberts says the Fed is different from the FTC. But frankly, what he says is that it has a specific history and a specific power is true of every independent agency. Each of them have specific powers and specific histories, right? I think what is really being said here is that John Roberts likes the way the Fed works. He likes its mission. He likes its independence, and therefore he wants to preserve it. But he does not like, he has a long history of animosity to the kind of work the Federal Trade Commission does, the imposition of regulations on the basis of an impartial and nonpartisan basis that get in the way sometimes of what businesses want to do, and that this is capricious. This is not a general principle that's being used. And Amy Coney Barrett, who sided with Roberts in allowing Trump to fire Slaughter, dissented, right? Yes, in the Cook case, and said, look, if this works for Slaughter, it has to work for Cook. And so the idea that in one of the places where Trump lost, it appears he lost only because John Roberts was unprincipled, was not behaving the way a justice to the Supreme Court should behave, was not conducting the court as a court, right? But much more as a policy institution, saying the policy implications of keeping the Fed independent are good. The policy implications of keeping the FTC independent are bad. Therefore, I'm going to have two different principles in these two different cases. It is deeply disturbing when the court acts that way. So we've got a lot of cases here: campaign finance, mail-in ballots, the fundamentally important case in Louisiana versus Decay about racial gerrymandering. And we'll get into that. Cases to do with transgender athletes and conversion therapy, gun cases, asylum policy that I've already talked about, deportation protections as well. Sorry, I've really talked about deportation protections. We'll get into asylum policy. Before I do all this, though, and I do want to do this with you, get into the details of these cases, I want to spend a little bit of time on this court. And this will be review. I am going to spend a few minutes on how we got this court. And I start, as I have in before, with a juxtaposition, with a contrast. And the contrast is between the Warren Court, right? Perhaps the last time there was a fundamental shift in the direction of American constitutional law. Started before Warren, right? It started in the 1930s with the switch in time that saved nine and ended the Lochner era in the history of the court, made it possible for FDR to continue growing the regulatory agencies that Congress had started creating in the 1870s with the Interstate Trade Commission. But the Warren Court is really at the heart of the 20th century jurisprudential revolution, the rights revolution, as it's called. And here I just want to say, I don't think FDR, Truman, Eisenhower, the presidents who constructed this court by appointing the justices, foresaw or intended that the court would play this role. They looked to appoint justices who would be sympathetic to their overall judicial philosophy and who were well qualified. But they did not have a specific judicial philosophy or agenda in mind. They were also just looking to appoint the best jurists, the individuals who displayed the judicial virtues to the highest degree to the court. And the right idea that the judicial virtues don't just include a certain kind of restraint and forbearance. You can't, just act on the basis of your politics, your partisan beliefs, your intuitions when you're a judge. That's extremely important, but also a positive characterization of what you're doing, that you are attending to, right, an institution, the rule of law that is, right, maintained via gradual and stable continuation of legal norms or adjustment of those legal norms as the times change, the circumstances change, the issues being addressed by the law change, or the norms and culture of the people whose law it is change. And that speaks then finally to a third attribute of the judicial virtues. You are a principle for the sovereign people of the United States. You represent them not in the way a politician does on the basis of partisanship and electioneering, but in a more fundamental sense, you represent their constituent power, their ability to put their stamp on the Constitution. You can't entirely substitute your judgment for the people's judgment. And so, right, I want to say, right, despite the fact that we have here, right, 9 white men, not a very representative group, they were in certain respects at least chosen in the way that Supreme Court justices have long been chosen in the history of the court, not to produce a particular outcome per se, but simply to get on the court people with a strong judicial character, the best legal minds, to do the work then of making sense of the Constitution in the moment facing the challenges that we face. And here then I have the 9 current justices of the Supreme Court, and I need to point out that 6 of them are cut from the cloth of the Federalist Society. And so I have Stephen Tillis's book on the Federalist Society and the conservative legal movement also on the board. We've talked about this before. Let me just do this briefly because I think it helps to understand how those 6 justices were selected, what they were chosen for. And here I want to say it is not because they possessed to the highest degree the virtues, the understanding, the mind, and knowledge that would allow them to distinguish themselves as jurists and to do the work of the Supreme Court of the United States. Here I have to go back to the Powell Memorandum from 1971, the eventual Supreme Court Justice Lewis Powell, when he's still working for the American Chamber of Commerce, writes this confidential memorandum that says, look, the direction that American law has been taking, guided by the Supreme Court and the federal bench, but also by the Congress and presidents of the United States who appoint those judges and justices and who make this law, has been hostile to a less regulated free enterprise system for a long time and has been hostile to the traditional values of the United States, which include but are not limited to a deregulatory free enterprise, entrepreneurial environment. And so if we're going to address this, we need to concentrate not just on lobbying the current members of Congress or electing new presidents and new members of Congress. We need to fight it at the source of the problem. We need to fundamentally remake the federal judiciary and even more deeply so American legal culture. And so this is an incredibly ambitious goal the Powell Memorandum is launching. And it was met with a great deal of support, in particular from some of the wealthiest corporations and individuals in the United States. And I'll say that the Koch brothers play a really important role in their family network and all of, the wealthy individuals that they organize. And in the end, this leads to the founding of the Federalist Society, the Heritage Foundation, other of what have become the fixtures of the think tank and policy making apparatus on the right. And in the end, over $500 million is spent, right? The head of the Federalist Society confirms that Steve Tillis's forensic accounting is accurate, and Tillis himself says, look, this is a conservative figure. They're not telling us when they spend it. You got to go back and try to reconstruct how much was spent. But at least $500 million over 50 years was waged on this campaign to remake this majority, right? And so one way to refer to this majority, right, the old majority on the court, and frankly, almost every other majority on the court, is in certain respects, it is organic or spontaneous. It is the product of, individual decisions about who would be a good jurist, a good Supreme Court member. This majority is the product of a campaign. It's like a campaign to elect somebody to Congress, or even more like a lobbying campaign to ultimately capture a regulatory authority. And I think part of the reason that ultimately the contributions and expenditures were so hefty, sizable, and the massive money spent here was the recognition that probably capturing the Supreme Court is the single most effective way to shape policy and regulation in American government in the 20th and 21st centuries, right? And so the idea that this is a target, the idea that if you can get the majority on the Supreme Court, you don't need to win every election to impose your will on American law and American regulations. That in particular, if you can get a strong and stable enough majority on the Supreme Court, you can even dispense with the judicial virtues, with respect for stare decisis or precedent, with wildly creative and inconsistent readings of statute and the Constitution, and in the way that I tried to show with Trump v. Slaughter as opposed to Trump v. Cook, you can do two things that are totally inconsistent with each other on the same day. Because frankly, if the Supreme Court is given the authority to invalidate laws via judicial review, an authority it does not have in the Constitution, if it is given the authority to impose its interpretation of the Constitution on the other two branches and the American people, what I often call its maximalist and supremacist authority, which again, the Constitution does not grant it, then it is by itself a five-person wrecking ball for American law and democracy. And this is increasingly the way this majority operates, and this is what it was made to do. This is why this patient campaign attracted so many contributions. And by the way, I'll just add very quickly, it is an originalist majority. And really, it's the first originalist majority in the history of the United States. Originalism, despite its name and content, is of a relatively new minting. It did not exist prior to the 1980s. And by the way, none of the framers or founders were originalists, believed that the best way to interpret the Constitution and the laws is to understand what they meant for the people who framed them or ratified them, or for the generation in which they originated. That was not the view, of most of the people involved in drafting the amendments to the Constitution. As a matter of fact, they didn't often have a unified view. So the search for that intent behind the law is specious. It is incoherent. It's relatively new. And by the way, it is precisely the license to undo what had been done by the earlier courts, like the Warren Court, which understood itself to be the shepherds of a living constitution, the principles of a people whose constitutional ideas were evolving. And so this puts the current court, diametrically opposed to much of the history of constitutional law. The reason I say we're entering a new era, that this is a fulcrum point, that we are tilting into an entirely different era of constitutional law, is because this majority starts from a position of interpretation. The Constitution does not interpret or administer itself. We have given that work over. I don't think intentionally, deliberately, democratically, or legitimately, but nevertheless, the Supreme Court has claimed for itself the work of interpreting the Constitution authoritatively. They have to do that work, Somebody has to do that work. And if they do it from a position that is inflected with this originalist idea, they're going to do it in a way that is fundamentally hostile to most of the last 100 years of the Constitution. And I want to be as clear as possible. They are not just saying, we want this Constitution to be read in our way and only our way. They are also partisan. They are also doing things that are beneficial to the Republican Party at a period when the Republican Party is struggling to attract a majority of American voters, and they are doing things that will advantage the Republican Party's ability to hold on to power, So with that background, let me say just for a minute, a little bit sympathetically, what I think this court thinks it is doing, because I think it's important to understand that it is, right, offering a constitutional theory that it views as legitimating what it's doing. So to begin with, it believes that the two fundamental revolutions of the last 100 years in American constitutional law, the rights revolution, so the expansion of freedom of speech, freedom of religion, rights of conscience, the civil rights revolution, the voting rights revolution, eventually the protection of marriage equality for gay people and LGBTQ rights, that this right revolution, which is not restricted to the court, but which the court has been at the right at the cutting edge of many times, and has then protected on a variety of occasions. Of course, I should have mentioned the right to privacy, the protection of contraception, and then eventually abortion as part of that revolution. And with it, also the vast expansion of the administrative state, the growth of these new independent agencies, the grafting of them into the constitutional structure, that these are aberrations, that these were not, in fact, permitted by the explicit content of the text of the Constitution of the United States, that they were, quote, judge-made law, and that therefore stare decisis, respect for precedent, would be accommodation of unconstitutional court-made law, and that they are there, if you will, to turn the clock back because the decisions were always bad and illegitimate decisions, right? So to take the expansion of the administrative state first, and here we have the overturning of the Chevron precedent, which allowed right administrative agencies to exercise discretion when the statutes that enabled them directed them to do so. And then more recently, the Slaughter decision, which allows the president to override Congress, which says that these agencies, boards, need to be independent and impartial, constituted on the basis of bipartisanship and expertise. And in both these decisions, right, the Supreme Court is using understanding of the executive branch that says it is a unitary executive, that the president, therefore, is the mechanism of accountability, and that the right president needs to have the ability to change the composition of these boards. The judiciary needs to have the ability to oversee the expertise and the regulations that are being promulgated by the administrative state, and that this is right a pushback against a ideology of technocratic competence that has no place in the Constitution. I'll say this very quickly, right? Congress did create these statutes. Congress is electorally accountable. Yes, they insulated these boards from the president's unilateral control. They did so because they thought they were too powerful. These agencies, if they're going to be located in the executive branch, also need to be protected from a kind of partisan hijacking to simply perform the president's will or whim, especially for them to be weaponized for partisan ends. And right, there was a doubling down on this idea in the aftermath of Watergate. But having said that, the Supreme Court thinks that the whole enterprise was never justified. The rights revolution, at least important aspects of it, like the right to privacy, not mentioned in the Constitution. And here I'll just say this very quickly, right? The Constitution has a problem. It is very difficult to amend. It is, in the words of one of the constitutional scholars, one of the leading comparative scholars of amendments, among the most rigid, if not the most rigid, the most difficult to change constitutions in the world. And so much of the project of updating the Constitution, of incorporating new ideas into it, has been driven by courts, especially by the Supreme Court. And the result is that over the course of the 20th century, new values and principles were discovered in what are sometimes called the interstices of the Constitution. They're not explicitly enumerated, they're implied by the values, by the penumbra, it's sometimes called, of the Constitution. And the Roberts Court majority is skeptical of this effort to update the Constitution to incorporate new values as the people of the United States evolve, because it's not actually explicitly there in the Constitution. And by the way, while that is the argument against privacy and specifically abortion, there are other arguments that, for instance, the sensitivity to race that the Voting Rights Act and the 14th Amendment indicate may have made sense in a particular moment, but they don't make good sense now. And so even if those are constitutional values, they no longer should be enforced in an aggressively race-conscious way, because we've overcome that history. I'll say this very quickly, and we can talk about it more next time. In saying so, the justices are replacing the judgment of Congress and of lower courts with their own judgment. You might say, well, what else are they supposed to do? Judicial virtue suggests, look, the Supreme Court is not constituted in the fact-finding way that a lower court is. They don't hear a whole bunch of experts come in and tell them about how much racism there still is in the United States. They don't get to conduct the hearings for a year that Congress conducted that changed the minds of many Republican members of Congress in 1982 when they're reauthorizing the Voting Rights Act. And so, no, maybe the justices of the United States Supreme Court need to show some deference to the lower courts and to the members of Congress, rather than arrogating to themselves based on, I don't know what, but it certainly seems like watching too much Fox News, belonging to a right-wing media system that seems to be very closely aligned to the views of the majority of the Supreme Court, especially on issues of race and gender, religion, and tradition. And so finally, this idea of the unitary executive, right, which is, it seems to be, right, licensing a vast increase in the unilateral control over tremendous power and information contained in the administrative state that was delegated on the understanding by Congress that it would not be subject to unilateral presidential control. And so in a really important way, and in the dissent in the Slaughter case, right, the three liberal justices said, look, this is constitutional bait and switch. Congress gave these powers to the executive on the understanding that there would be constraints on the president's ability to unilaterally control them. There's this issue in constitutional law that's referred to as separability. If you're going to strike down one portion of a law, the president can now, right, unilaterally reconstitute the boards of these agencies. Does that call into question the rest of the law? And to be as clear as possible, it doesn't seem nearly so clear to me that these are separable issues. If you're going to make the Federal Trade Commission and the EPA and this whole other array of, right, executive agencies, including the Federal Communications Committee and the FEC that regulates our elections, if all of a sudden you're going to give the president much more power over them, shouldn't Congress have the opportunity to reconsider what their powers are going to be? Shouldn't you invalidate the law in total as opposed to invalidating just the one portion that you don't like? And if you invalidate that one portion and that fundamentally alters the effect of the law, what gives you the authority to do that? Right? That's a deep question, especially when we recognize that the current president of the United States is inclined already to have a maximally expansive view of executive power and, frankly, to use that power in abusive ways. It's disturbing, and it seems to me to be revealing as well that the six justices in the majority on the Supreme Court are not concerned about Donald Trump's abuse of power, that they are, in fact, enabling it rather than constraining it. Let me stop there. There's a lot more to do with this, but I know we're out of time and it's getting to be close to lunchtime. Anybody want to weigh in? Who has thoughts, comments? You can talk about Plattner or Iran as well if you prefer, but I do hope we'll have some time to talk about the Supreme Court. Who wants to start us out?
I lost this.
I'm hearing you, Sandy.
Oh, sorry. I somehow lost the place where I put my hand up. I'm really, really worried about Alito and Clarence Thomas, in that the president will want to encourage them to resign or pay them off to resign, and then put in two more extremely young conservative justices. I think and I want to thank you. This was a wonderful summary and study of the role of the Supreme Court right now.
And I want to endorse what my wife just said, because I'm a lawyer and I'm horrified by the Roberts Court's lack of respect for tradition and precedent, and their willingness to do violence to a lot of our things we thought were immutable.
Yeah, thank you both, and I'll return to Sandy's question real quickly or comment, right? And I'll just point out, yes, I share your alarm that whereas Justice Ginsburg, right, didn't right allow a Democrat the opportunity to replace her, and in many respects the fundamental shift in the court reflects, right, Ginsburg being replaced by Amy Coney Barrett, and that I think it's Amy Coney Barrett, but being replaced by somebody very conservative, right? And so this remarkable shift in the balance of power on the court. And then I'll just say, while I share your alarm at the idea, and I don't know if it's Alito or Thomas or Roberts, who it is, but that the conservative justices will be more attuned to the possibility that the next president of the United States will be a Democrat, and that if they don't resign or retire now, they will potentially be replaced in a way that would undo their jurisprudence. But let me then say two things. The first is, frankly, that speaks to not just, right, a worry about two or three or four people on the court. It speaks to the way in which they're governing, the way in which they're adjudicating. They recognize that it's only if people like them are on the court that their decisions will be upheld. They're writing only to each other, to their peers, to a narrow ideological agreement, and not in a way where they believe, even if they retire and they're replaced by somebody of a different view, that person will uphold their views. That speaks to a shift on the court. And then the second thing I want to say is this right, issue. The president gets to appoint someone. He can appoint somebody young. If the Senate confirms them, if that person stays true to the course that they were appointed to further, and if they have a long life, it may be that 40 years will go by in which, right, more than 10% of the power of the most powerful institution in our federal government resides in the hands of a single individual. And over the course of those 40 years, an awful lot may change in our country, and we're saddled with this person because they were appointed in 2027, right? And think about that. In 2067, they may still be there doing Donald Trump's dirty work, despite the fact that, maybe the history of the United States is now written, let us hope, in a way that says that Donald Trump was the dying gasps of a terrible moment in our history when we were still resisting the transition that we've now successfully made into being a multiracial, post-traditional, let us hope, green society, right? And so there's a problem with this institution. It gives too much power to too few people who are unaccountable. And so, yes, we should be worried about Alito and Thomas and Trump conspiring to continue the conservative stranglehold on the Supreme Court. But we should also be noting the structural roots to this. The story we looked at today, the story of a 50-year campaign to capture the majority on the Supreme Court, shouldn't be possible. We shouldn't build our institutions to incentivize the hyper-wealthy to capture them and to be able to exercise disproportionate power in our society via a shortcut that insulates it from accountability. The problem is not just with those two men. The problem is with the institution. The institution needs to be changed or junked. It doesn't work anymore. Yeah. Thank you, Sandy.
Thank you. It seems kind of hopeless, though.
No, I don't think it's hopeless. I think the answer is that a new Democratic majority in control of our government will find ways of repacking the court so as to better reflect the consensus of public opinion.
Yeah, I certainly hope you're right, and that on the one hand there will be a Democratic majority, and on the other hand that at the top of their agenda will be court reform. Right? For more than a generation now, Republicans have cared much more about the composition of the Supreme Court than have Democrats, and this has to change. Right? The reason that we have this destructive majority, this anti-democratic majority, this majority that is going to make our society much more divided and much less safe for the foreseeable future until we do something about it, is because Democrats, frankly, have not made this a top priority. And so, yes, this is an issue where the party has got to get better at paying attention to it, working on this, at fighting for this. Anybody else with a thought or a comment for today? I will let you go. It's good with, as always, being with you. And we will, I hope, be able to resume this conversation next week and pick up where we left off, because there's a lot more to talk about. Thank you, guys. Have a good
day. Thank you.
Bye, guys. Appreciate it. Take care. See you soon. Bye-bye, everybody.